Good afternoon, welcome to the Glasgow Forum for Scots Law. Very pleased to have you here, some new faces, so thank you, and welcome to anyone who is watching online. Very pleased today to have Bobby Lindsay, who's a PhD student here in the University of Glasgow, and Bobby's going to be speaking about the functions of public policy in international private law. And again, Bobby's picking up on our theme, which we've been looking at for this semester, which is private law and public policy and the various ways in which they interact. And I'm very pleased that Bobby can bring an international element of some sort to this topic. So we'll have, Bobby will maybe present for about 25, half an hour, and then we can have some discussion afterwards. So if you're watching online, you're very welcome to tweet in a question. We're just like X Factor. I don't know if you can tweet questions.
More people are watching us than X Factor.
I don't know if you could tweet questions to X Factor. Maybe you can. However, we shall move on.
I'm a voice man myself.
To more interesting things. Bobby.
Thanks, Stephen. Well, as you said, in this seminar series so far, we've been speaking about various tools and various mechanisms through which public policy concerns that are seen as desirable can be secured and can be implemented. Judged against that yardstick, my topic doesn't fare very well, because international private law is essentially a system of law of signposting. It says you can sue in this jurisdiction using this law. It doesn't really have much concern for the underlying substantive justice or policy merits of the ultimate decision. My very, very modest aim today is to attempt to convince you that that's not 100% true, and there are ways in which public policy concerns can be reflected. So we'll operate a sort of nodding system for you to move the slide on. So first I'll begin by mentioning some of the forms and functions that public policy can take. I'm then going to look at a particular area of where public policy seems to be a complete and utter irrelevance, and the goal of my broader research is to try and say that policy should have a role there, and that's to do with the exclusion of foreign public law. And this all turns around demonstrating that there's a place for what we call positive public policy, this idea that policy can come in and create something, as opposed to its normal role of denying or deflecting. And at that stage involves defining what positive public policy is and sort of disaggregating it from other things and bifurcating the different types of it that can arise. After that, I will go on to show what the implications are for the exclusionary rules. This is a very selfish exercise in that it allows me to talk a bit about my PhD, but afterwards I am more than happy to talk about any aspects of the subject whatsoever in its policy implications. First though, by way of introduction, I should probably speak about the forms in which public policy can take. Now, it may be that they can be accommodated within the rules themselves, but in the sort of European tradition, which includes Scotland and England here, we adopt what we call a jurisdiction selection approach, which involves our choice of law rules looking like something like this. So the law applicable to whatever we're arguing about is the law of that place. It doesn't look at the facts before the court to work out, oh, that legal system should apply, or it doesn't look at all of the potentially applicable legal systems and say, well, that's the best law, or that has the most policy reason for applying, so we'll apply that. It just goes, that will do. The other way in which policy might be secured is if the judges are a bit naughty and play with these rules to try and get answers that they like. And English judges historically do this a lot, and they do it a lot with contracts. If a contract is to do with reinsurance or with financial services, they will do their best to say, well, okay, the parties didn't put a choice of law clause in it, but they actually meant English law to apply. And if they can't do that, they'll just say, well, English law should apply anyway. So there's a way to get public policy concerns in through misapplication of the rules, and then there's an overt way of doing it through the broad doctrine of public policy, which sits as a corrective to the choice of law rules as applicable at stages 1 and 2. and also the doctrine of mandatory provisions, which we'll return to in a minute. And these can function in what I would submit two ways. The first, which is incontroversial, is as a shield, to use a horrible metaphor that we'll return to. The idea that they're reactive or deflective, something odious is tried, enforcement of something odious is attempted, and the forum can go, no, thank you, we're not enforcing that today. But I would suggest that, and to extend this metaphor, there's a sword function, a sort of creative way that you can use it to give rise to rights and duties and relationships where none would previously have existed as a matter of choice of law. So that's about the forms, and yeah, that's just to emphasise that I'll be focusing on that. What about some of the functions? Well, there's three main functions that I'll speak about today. The first one being proximity. And I would suggest that 99 times out of 100, this is the only thing that a choice of law rule can achieve. It can achieve some degree of connection between the legal system that is selected and the matter before the court. And this is useful because it means that parties aren't upset by thinking that this law will apply and finding out that the law, wherever they happen to be at that time, will apply. And it's also helpful from the point of view of a state, in that the state might have certain interests in certain matters to see that its law is applied instead of something else. The next function, which isn't really a function, it's more of a get-out clause, is the idea of protectionism, which is that the forum may well decide to say, you know what, I mean, I know this is an international case, but we don't like that, let's just make this a domestic one, let's try and protect our interests by applying our law. And there are some emanations of that which are okay, and some emanations of that which are quite dodgy. And that's to be distinguished from the last function, which is the idea of protectivism. And what I mean by that is that's where certain classes have been picked out for being perceived to be disadvantaged, and the idea is that some advantage can be conferred upon them by a rule of jurisdiction or a rule of choice of law. So to give you an example of those three functions in action, this is from just the law of marriage. So in terms of proximity, to assess whether or not a marriage is essentially valid, so whether the parties consented and had capacity, you apply the law of the antenuptial domicile. So that's the legal system to which the party belongs before the marriage. Obviously that's a sensible rule because knowing that legal system, having lived in that legal system presumably for a while, they'll be aware of the requirements of that legal system. It means that the validity of a marriage isn't tested by whatever legal system they happen to be resident in at the time of testing. And also, on the flip side, the state of the domicile might have some interest in having its law applied. But that's all that rule achieves, its proximity. So that domiciliary law might include prohibition on interracial marriage or something like that. That rule by itself can't do anything to guard against the application of that. In the Scottish context, we also find a special rule which is kind of protectionist, which says that if a marriage is celebrated within Scotland, then it doesn't matter what the law of the domicile says, you have to satisfy the requirements of Scottish domestic law. So if two parties aged 12 could marry under their domiciliary law and came to Scotland, it's completely irrelevant that their domiciliary law says 12 is the age of capacity to marry, because Scots law says it's 16. So that superimposes Scots law onto the question to try and safeguard our interests. And that's a fine rule insofar as it goes. There are bad examples of this, but let's stick to this. And as for example, protectivism, there was an old rule that in order for you to sue for divorce, you both had to essentially have lived a substantial part of your life in Scotland. This started to pose problems in cases where wives had been deserted by their husbands, and by deserting their wives, the argument was, well, they've lost their Scottish domicile and they've frustrated any assertion of jurisdiction by the Scottish courts, so we shouldn't allow deserting husbands to desert their wives and get away with it. So a special rule was introduced by the judiciary, which essentially says that a deserted wife could sue, even if the deserting husband had subsequently acquired a foreign domicile. So those are the three of the forms that public policy can take in private international law, and three of the functions that it can serve. I'm not saying that's exhaustive, but those are the three that I've picked out today. My research in terms of the broader PhD focuses in on one particular or three particular rules where there's really no policy impetus whatsoever. And that's the rule that English and Scottish courts don't enforce penal, revenue or other public laws of a foreign state. And this grew out of 18th century protectionist concerns of not wanting British traders to be subject to prohibitive duties when trading abroad. But it's been extended in a rather worrisome fashion. So a judgment against a tax exile who's resident here can't be enforced. If me and the parking municipality in an Italian city decide to contract that I will pay those parking fines over the course of a year or so, just because I've converted that into a contractual right, this rule will block enforcement of that. It also blocks enforcement of directors' duties against directors who have in some way caused tax to not be paid. So it's been extended quite a bit away from its very dubious origins. And one of the aims of my thesis, which ties into the topic today, is to try and justify a policy-based exception to this. And this depends on the validity or the otherwise of 5 claims in particular. The first claim is that there is a positive aspect to public policy. Second is that that doesn't just mean that there's a doctrine of mandatory provisions. Third, by positive, we really mean that public policy can be creative. It can create rights and duties where none existed as a matter of the applicable law itself. Fourth, that public policy can do this either by looking at what the law of the forum says and applying that to the situation, or it can pick from a third system which wouldn't otherwise be applicable to give rise to those rights and duties. And the fifth claim is that if all that's true, then I think they should operate as an exception to the exclusionary rules. So, positive versus negative, what do we mean? Well, the negative dimension is very well established, and if you just click through, there's 3 examples here of things that public policy will not stand: actions by prostitutes to recover repayments from paramours, prohibitions of interracial marriage, and expropriations of aircraft contrary to UN resolutions. But these are all examples of negative public policy, or public policy as a shield, and each of these an unjustifiable or an unsavoury provision was sought to be enforced, and the forum put up its shield and said, no, thank you. The question of whether there's a positive dimension has been, well, it's been denied in a very, very recent edition of a very good textbook, again using this metaphor of sword and shield. But if we are going to pursue the positive dimension, the first thing we need to do is to separate it out from what we call the doctrine of mandatory provisions, because it's often said that the public policy in its positive sense would just mean mandatory provisions. So to give you an example of one of those, this is a very recent one. It's Section 4, subsection 1 of the Consumer Rights Act 2015, which is to do with unfair terms. And it says that if the parties to a consumer contract choose the law of a non-EEA state, so if they choose New York law or if they choose Namibian law, and the contract has a connection with the UK or close connection with the UK, then even though they've chosen a foreign law to govern that contract, the unfair terms provisions of the Consumer Rights Act will be superimposed on top of that choice of law. So this is a technique. It's not often used in the UK. We find it in the Consumer Rights Act, we find it in some of the employment legislation, we find it in one of the new insurance acts. But if this is all that public policy is, it doesn't take us very far. And while you can see the functional similarity in that these are just discreetly formulated emanations of particular rules of public policy, they don't exhaust this category. And the distinctions, as I would put it, and just if you just click through this next slide, is that public policy is always discretionary, and the judge does not have to find this rule contrary to public policy. And it necessarily involves the judge taking a view of the foreign law which says, well, that just can't stand in our legal system. I am a judge of this system, and I cannot act against our fundamental values. Mandatory provisions, on the other hand, are not discretionary. It goes in the name, they're mandatory. There's a statute which says to the judge, you must apply this law, no matter what the applicable law is. They are almost always as a result of legislative direction. What that means is that, unlike public policy, they don't involve the judge having to look at the foreign law and say that it's somehow deficient. It doesn't involve any condemnation of the otherwise applicable provision. It just involves the judge saying, sorry, my legislator has said I've got to apply this law and I shall do that. So that's not what public policy in its positive forms. So what is it? Well, there's three possibilities. The first is this idea that, in a positive sense, it insists on the application of the domestic law. It's a sword, however, is when it looks at the relationship between the parties, or there might not be a relationship between the parties at all. There might be no liability as a matter of a choice of law. There might be no right, no duty. And if that offends the interests of the forum, it can step in, I would suggest. And a good example of this, if you click through this, very quickly, this is, that's perfect, thanks. This is the way in which it might work by drawing upon the law of the forum itself. So it will designate an applicable law, which doesn't hold the two parties in a relationship. It says there's no right and there's no duty. If the lack of that right and duty offends the public policy of the forum, then it can create a cause of action by drawing upon its own law. And it can create a relationship, or it can create a claim, or it can create a right, where none would have existed as a matter of choice of law. And a good example of this is a fairly odious case from Saskatchewan, I'm going to pronounce it today, which, if you put on the next slide, is Branco and Zurich Insurance. And what happened here was Mr. Branco, who I think was Portuguese, worked for a Canadian mining company, but he worked in Kyrgyzstan. And whilst in Kyrgyzstan, he suffered a terrible injury, and he came back very briefly to Canada, but then returned home to Portugal, but then decided to instruct counsel to sue in Canada. But he wasn't going to sue his employer, he was going to sue his employer's insurer, because in the course of settling the dispute, the insurer was quite naughty and exerted undue pressure on him to force him to capitulate. And why did he want to sue in Canada? Well, Canada is a weird jurisdiction because they recognise that not only can you get compensatory damages for a breach of contract, but you can get a punitive measure of damages. So it doesn't depend on the loss, it depends on how bad, how naughty the defender or defendant was. So the court in Saskatchewan took a look at this situation, and it found that the contract between Mr. Branco and Zurich was clearly governed by Swiss law. Not because there was a choice of law clause, but because everything had to do with Switzerland in terms of the arrangement between the parties. So the closest connection, the manifestly closest connection that this dispute had was with Swiss law. But Canadian law didn't like this conclusion. It thought, well, we like our punitive damages. Swiss law is too sensible, it only gives compensatory damages, so that's against our public policy. And the next step was, well, under our own remedial toolkit we can give punitive damages. So as a result, the Saskatchewanian, that's a word, lex fori superimposed itself and said, look, in this relationship there should be no claim for punitive damages under Swiss law, but we're going to create one for you. And this is a bit of a silly decision because the connection with Canada is extremely brief, extremely paltry. There was a short period of residence and the policy was payable in Canadian dollars. There wasn't much else there. But that tenuous link allowed the court to impose its own egregious remedial system. I should say that the Supreme Court of Canada disagrees with me on this. They recently refused leave to appeal on this. So well done, guys. But that's fairly uncontroversial, because the forum is just saying, well, we hold this principle dear, we can superimpose that where we see fit. In that case, they probably shouldn't have done it because of the lack of proximity. But in principle, that's relatively uncontroversial. What is more controversial is where the forum looks to its own rules and says, we don't create a remedy here, or we don't see a relationship here, or we wouldn't give title here. But we don't like that conclusion as a matter of public policy, even though our own rules would lead to that conclusion. So they'll look elsewhere, they'll try to find some other legal system in order to create a right or a remedy there. And the four steps we have here are, firstly, that the choice of law rules designate, again, an applicable law that does not give rise to a cause of action, that the forum thinks that won't do, that's offensive to our public policy. But then it looks to its own toolkit and goes, wait a minute, we can't really do much better, we wouldn't recognise a relationship here either. And as a last-ditch attempt, it fashions a remedy or a cause of action from some other system. So that's to say, one that isn't the applicable law or isn't the law of the forum. Now, this is an extremely extreme situation. It's not very well liked, and you can only find it happening, I think, in one case, which has been overruled. But I would suggest that we can save the reasoning in that case and find it being used in another area. Why it's so controversial is the obvious conflict between stages 2 and 3. How can the forum find a lack of a cause of action offensive to its public policy if it itself wouldn't create a cause of action there? And that's simply, the answer to that probably is that public policy doesn't care so much about the content of the law, it cares about the effects of applying it. And there are certain circumstances in which the effect of applying it is so offensive that the forum will just ignore its own choice of law rules and pull something else out of thin air. Now, this can only really arise where your choice of law rule is something very strict, like the rule that title to property is governed by the place where the property is located, or the rule that procedure is determined by the law of the forum. But there is a role for it. And the one case that stands out on this is the case of Loretson. And to explain this, I've done some great special effects here. So note the timeline. This is happening in about 1940. There was a ship, which if you click should appear. And it was a ship of Norwegian flag. And this ship sailed to a port in England. And if you click on that, the boat should sail. Now, while the ship was there, it was carrying on various things and entered into a charter party with a charterer who breached that charter party by not sailing, and therefore there was a claim to sue for the damages for breach of charter party. If you click, the claim should appear. There we go. In the background, of course, this is 1940. Europe is at war. By this point, Denmark had fell to Nazi occupation. And obviously the sort of pre-Quisling line was about to come to Norway. So the Norwegian government, before it removed itself to the United Kingdom, passed a decree that said any ship in the world that is off Norwegian flag will be requisitioned. Moreover, any claim that the owner of that ship will have against a third party will be enforceable on behalf of a curator appointed by the Norwegian government. They passed that, and within a week or so, Norway falls. So this curator that was appointed comes to London and knows that there's a good claim, a good amount of money owing for the breach of this charter party. And he argues, well, we need to get that money to the Norwegian government. This is a time of national emergency. The counterparty, the party that breached the charter party, said, hang on a minute, there's no way that could be possible because this ship was located in England when that decree was passed, and it's a fundamental rule that requisitionary decrees only have effect interterritorially. okay, what about the claim? Well, the claim is exigible against me in London, so that's where the claim is situated. Again, this Norwegian decree couldn't possibly touch this. The judge, Mr. Justice Atkinson, rejected all that and allowed the curator to recover the claim there. And his reasoning, if you can call it that, was essentially mapped onto these 4 points. First, the English choice of law rule, the lex situs rule, he thought, would apply English law. And English law didn't recognise that the curator could claim for the breach of contract here. The English court said, well, that's not on, because, you know, Norway needs all this money, and this is a time of national emergency. So what can we do about this? So it looks to the Lex Fora and goes, hang on a minute, there's no point in doing that, because the law of the forum is English law again, so we can't fill the gap using that. What it does do is it then goes, oh wait, hang on, Norwegian law says that you can determine the entitlement to claim here, so let's do that. And the judge said, England and Norway are engaged together in a desperate war for resistance, and public policy demands effect should be given to this decree. And the curator was able to recover. It's fair to say that nobody likes this case apart from me. And it's been deemed somewhat heretical, and if we see in the next slide, Mr. Justice Devlin, who was counsel for the losing side in Lorentzen, doubted it strongly. He said that public policy is not a positive force to be used to give an act validity which it would otherwise lack. And it was overruled, kind of, by the Court of Appeal in 2004. Why I want to return to it is that I think you can compare it to a later case, and this turns on the distinction between title in a proprietary sense and title in a procedural sense. Every case since, and every authority since, has treated the Lorentzen case as a case about title to property. Actually, it was about title to sue, and that's a procedural concept, which is slightly different. And one case that deals with a procedural concept, now I don't have a nice diagram. I do, however, have the best title of a case note ever, Of Temples and Phalluses and Such Like Things, by John Collier. And the abstract to this sums the case up beautiful. Whether temples and phalluses are juristic persons with rights to sue under English law. Now, I must point out, please, this isn't actual real phalluses. These were stone phalluses. And this was a case involving a Hindu temple suing to recover a 12th century bronze depiction of Shiva, which had been stolen from the temple and had somehow ended up with an art dealer in London. Now, the obvious claim here by the defenders was, look, this is a pile of stones. They can't sue under English law. True. But the judges thought, well, that doesn't seem quite right. That's against our public policy. So they thought, right, what can we do to fix this? Oh, well, the choice of law rule is the same as what would apply in the absence here. We look to English law again. English law wouldn't apply here. So let's look to a third system. Let's look to Indian law, which itself wouldn't have been applicable because it wasn't the applicable law rule, because this was a procedural matter, that was the Lex Fori. And it wasn't the Lex Fori itself, it was a third system. And therefore, it just reached into Indian law and said, yeah, you know what, why don't you go from this? Now, this is a clear example of public policy being used as a sword to create a right where one didn't exist, or a power where one didn't exist before. The judges don't express it in those terms. They express it as sort of taking the rule of English law and making it more flexible. But it can be expressed in these terms as well. And linking it back to Lorentzen, we can see that these are two examples where this use of public policy has been used. They've been used to introduce, by the back door perhaps, flexibility in an otherwise rigid choice of law route. My question is there scope for this elsewhere? Well, yes there is, because very, very recently, last year, in the case of Mohammed against the Ministry of Defence, this involved torture claims essentially against the Afghani security forces, which alleged that the Ministry of Defence officials had been complicit in handing over Afghani nationals to be tortured. And that gave rise to a principle of immunity called the Domestic Actor State Doctrine, that you're not allowed to sue and tort a Crown agent exercising Crown functions. Quite happily, the Court of Appeal here refused to apply that immunity there, and the dicta just wonderfully helpful for my PhD. A simple bar constituting an automatic defence against all claims is no longer sustainable. And in our view, in the present context, it is necessary to consider whether, in the particular factual circumstances of each case, there are any compelling considerations of public policy. Now, I gave a talk on that case in November last year. We're still waiting on the Supreme Court to come out with its decision. It's been well over a year now. Hopefully it will keep that line up, because again, this shows that a rule of the Forum's law, this sort of active state doctrine, can be overrode by public policy concerns in exceptional circumstances. Now, these are all exceptional cases, I admit, but the nature of my PhD, I'm not saying it's exceptional in quality, but it's certainly exceptional in frequency that these cases do arise. And what do we have on the next slide? Oh, we've got one case which is very pro this line of argument, and one case which is very against this line of argument. In Barakat, this involved simply a claim to return cultural heritage. It was held that that didn't fall within the rule that you can't sue for a foreign public claim, because all that the Iranian government was doing in this case was suing on an ordinary proprietary title. But the court said in obiter, if that wasn't the case, if we held that this did fall within the public law rule, then look, there's a UNESCO convention on cultural heritage and its return, and everybody wants to return public cultural heritage to its state of origin. There's a big cultural interest in this, so let's say that there's a public policy exception here, maybe if we fall within that. And it didn't really commit itself to that, it only said it in one paragraph. And it's not clear whether that's limited to the specific case of cultural property, or if you could expand it, as I would like to do, for the across the board to revenue claims and penal claims. The more recent decision, the Abacha decision, involved General Abacha, who was the Nigerian tyrant who stole millions and millions of pounds worth of assets from Nigeria. Some of those assets ended up in London bank accounts, and this was an attempt by the US Attorney General on behalf of the UN Kleptocracy Recovery Programme to get a freezing injunction to stop those assets being dissipated. And the Court of Appeal in that case said, no, we're not going to let you do that because you're trying to enforce the criminal law of America by doing this. And clearly there's manifold public policy reasons in favour of allowing that claim to arise there. You're trying to stop a despot from disseminating assets across the world. But for some reason or another, the Court of Appeal wasn't presented with the argument that public policy can make the penal rule bend. So that's all that I've got to say. When it comes to questions, like I said at the outset, I'm not wedded to that very technical and narrow body of the paper. If anybody is particularly interested in those arguments there, I can pass them on a draft of a very short paper that I've written on it. But any questions to do with private international law itself and its public policy aspects will be welcome. And there's a very not so subtle hint, if you click the thing, on the sort of questions that might be asked. I'm not sure. But yeah, just if anybody's got anything to add or any comments, or if you think that any of those claims that I put up on the slide were made out there, that would be very helpful.
So thank you very much, Bobby. That was a superb paper, very analytically astute, picking out some of the important things here that sometimes we can speak about public policy, and it's a term that can be used by courts, and it's a term that can be used by researchers, and it's a term that can be used by legislators. And I think the way that you've organised that discussion there is actually a really helpful way to see how public policy can manifest in different areas of the discussion. So yeah, thank you very much. So yes, Bobby's asking for questions. Anyone have a question? Very welcome to ask a question.
Well, to take the bait from the flag.
So there's a European flag. Well, it's not. Is that a European flag? How many stars
Yes,
is on
EU,
that?
It's EU. It's got nothing to do with the 27 member states. It's just the number was thought to be perfect.
Ah, right.
Is it not the original members?
No. And they stole it from the Council of Europe as well.
All right. Well, I mean, obviously, with the decision in June to leave the European Union with Britain, and the failure, I would say, of the British government to make any clear resolution of what's actually happening with regards to that, what do you think the outlook is in terms of the application of international private law across Europe as Britain is concerned? Because presumably we're out of the treaties.
Yeah, well, that's a big question. There's some things that, if you look at the approach that the government has taken, you've got this idea of what they call the Great Repeal Bill, which pulls in certain parts of EU regulations and just makes them, transmutes them, transposes them into EU law proper. So that will take some things in. That will take the suite of regulations on choice of law for contractual obligations and non-contractual obligations. But they will still apply if that regime ever comes into force, this Great Repeal Bill. And they'll just operate as they are in the time being, because there's no need for reciprocity in those. We apply those whether the legal system that we're pointing at is France, or whether it's New South Wales, or whether it's Madagascar. They're not wedded to the EU like that. Where we start to run into problems are this whole system of judgment recognition. Brussels 1 for commercial things and Brussels 2 for family things. Yeah, we're going to be disadvantaged by not having them. Even if we put them in our law through this Great Repeal Bill, they're not going to be, or we're not going to count as a member state in the eyes of the other member states as they apply these regimes. So while we might give a judgment pursuant to the provisions in Brussels 1 or Brussels 2, that might not be enough. We won't count as a member state, and we'll have to satisfy their criteria for the same types of judgments that you'd get from Singapore or Australia or something like that. It's not clear if we're going to be able to negotiate something to replace this. In the family sphere, in terms of incoming judgments, we're probably going to recognise a lot of EU judgments that we would recognise just now. All you need for a sort of court-based divorce is that the parties were habitually, or one of the parties was habitually resident in the state that granted that divorce. So, mapping that onto the rules that exist at present, there's not really going to be too much of a problem, because you need to be habitually resident, or somebody needs to be habitually resident under Brussels 2 bis before you can bring a claim for divorce. So any divorce granted under B2 bis should in principle be recognised and enforced within the UK. Flip side, however, is we don't know whether the same is true of our divorces going outwards. Think of the children. The Hague Convention on Child Abduction still applies. Pakistan just become a signatory to it. The EU dimension isn't so pronounced there, and not for me to move to the plight of children, to the plight of insolvency practitioners, but the insolvency regulation is going to be a huge pain in the bum to try and replace, because it operates really well and it allows you to coordinate proceedings that are going on across 7 or 8 member states with ease. Without that, we're going to see some problems arising in cross-border restructurings and cross-border administrations and things like that. What else are we going to lose? Well, our own rules don't have special savings for consumers or employees or insured parties. And okay, we could bring them in as a matter of legislation, but I mean, we're going to be legislating for so many other things. I just don't think we're going to do it. So employees might find that they'll have to sue their employers in other countries, whereas at the moment, an employee, however you define them, can sue their employer in the courts of their domicile. So there was a case in the Supreme Court that it settled, I think, involving a multi-million-pound reinsurance broker who had a contract with a New York reinsurance firm, and that had a choice of court clause in favour of New York. But the English courts refused to give effect to it. They said, you must sue in England because of what EU law says. So we might lose it in cases like that. But overall, I mean, it's going to be a pain to tidy it all up. I'm not convinced there's too many areas where we're going to be massively worse off. I'm slightly worried about the family law situation, especially because it was the one nobody really thought too much about. Which is, although I noticed that The Guardian had a list of 20 reasons why Brexit will be more complicated than you think, and somewhere in there was a mention of international family law. But as I said,
any other questions? I was maybe going to follow up on that. I have two questions, but I'll do a follow-up question. Is obviously Rome 1 and Rome 2 have made life easier for courts, and also there's been a lot of coordination in other areas like insolvency. But do you think the common law is robust enough and is developed to a state of maturity in the UK to the extent that even if we do take away all of this, there's still enough left there? Or is there going to have to be quite a bit of decision making done on the basis of the common law to get it up to speed?
Yeah, well, Rome 2, the sort of delict rules, we don't have too much of a problem there because there's a statute, 1995, it's titled Private International Law Miscellaneous Provisions Act, which contains choice of law rules for delict. So they would apply in the absent, and they're not too different from what we have Rome 2. The big difference in the delictual context is that at common law, the quantification of damages is a matter for the law of the forum, and that's why everybody wants to sue in England or wanted to sue in England for personal injury and still wants to sue for defamation. Now that Rome 2 is in place, that's all a matter for the applicable law, so there's less incentive to forum shop. So if you were able to, I mean, it would all depend on legislative time being given to patch up the old rules in light of experience, but it's never going to happen. Contract, there's an argument that you'd go back to the Rome Convention. Part of me likes the flexibility of the common law, but not at the choice of law stage. I quite like it at the jurisdiction stage, this idea that if you're suing me in an inappropriate court, then the court has a power to say, no, you should sue in a more appropriate forum. But under the Brussels 1 regulation, at least, that power doesn't exist. If I sue you and you're domiciled in Scotland, that court can remove you from the jurisdiction. And as a result of that, you're getting a series of decisions. I'm not sure if this is a downside to losing the EU or if this is just a sort of accident of how the rules work, but a lot of systems, class actions, litigating in London, suing an English parent company, and because that English parent company must be sued there, the court can't give up its jurisdiction. You're finding that the English courts are being very, very willing to join connected parties and subsidiaries. So to give the Zambian diamond miners their day in court in London, just back through the linchpin of the parent being domiciled there. So there is some flexibility that would be nice to be brought back, but I don't think it's a worthwhile appeal. I really like this idea that I can go to Hungary tomorrow, get a judgment and give it to a sheriff's officer the next day and have it enforced. And I think that it's going to be a shame to lose that.
Yeah. Thank you.
I've got a question. I've also got a comment from Twitter, which might be a comment that relates to my poor live tweeting of what you were actually arguing in the first place, and I can't quite figure it out. So one of the things that I had tweeted when you were talking was that positive public policy is not the same as mandatory provision since they include no element of judicial discretion. Perhaps that wasn't really what you said, but I've had a response from Jan Jacob Burnham in Essex, a lecturer at the University of Essex, just referring us to recital 37 of the Rome 1 regulation. I'm not sure whether that is backing up your point or
Let me double check.
taking away from your point. I was just trying to, he's included it in the picture, but so it says, considerations of public interest justify giving the courts of the member states the possibility in exceptional circumstances of applying exceptions based on public policy and mandatory provisions. Okay. The concept of, so that's fine so far, and then the next sentence is, the concept of overriding mandatory provisions should be distinguished from the expression provisions which cannot be derogated from by agreement and construed more restrictively. That pretty much just backs up what you were saying, right, in the end?
Yeah, so the regulation draws a distinction between non-derogable rules, which can be principles of common law, like the rule on penalties or English law's fixation of consideration, and then there's overriding mandatory provisions, which pretty much always have to be statutory. And you do have a discretion as a judge to apply the overriding mandatory provisions of another country if that's got a sort of, that's a place of performance of the obligation. But in terms of applying the judge's own mandatory provisions, there's not really a hard and fast legislative direction that says you can't wiggle out of that.
Okay, right. I just thought since there had been some Twitter interaction, it might be
That's good. Well, it's good to know somebody's watching.
Nice to tell you, yep. My other question, which was just for me, was when they do, I'm thinking, especially in these cases where the forum has chosen law from a third country based on public policy rules, do they sort of explain what the public policy rules are? Because it seems quite strange to me, like in the Lawrenson case, that you would say, these are really important public policy considerations, and yet they're so important that we don't have them in our law. So we're just going to randomly choose the law of India to apply in this case.
I think that's such a special case, and I'm trying to do my best to try and resuscitate it and give it a veneer that it probably doesn't deserve. What probably happened there is that they were too late to put an order in council for it. So I imagine that Mr. Justice Atkinson had a little knock on his chamber's door from somebody from the Foreign and Commonwealth Office to say, could you please decide the case in this manner? It's a wartime situation cases. I mean, I'm suggesting that this framework can be pulled out of it, but really you've only got that and the Temple case, and perhaps the sort of new cases involving foreign torture, but they're all fairly extraordinary situations. It's not that the court's going to be doing this day to day, which is why it's in the PhD and not anything else.
That actually, unless you've got a follow-up.
No, just, good to hear about judicial activism.
Yeah, this is what I was going to follow up on, is I suppose under that heading, judicial activism, is picking out this sort of positive use of public policy. Do you see a trend? Is there anything underneath it that links together these judgments, or are they even, then if there isn't anything linking them, are they even referencing each other in judgments? So this really is sort of, you're looking at this and now interpreting it to...
Yeah, it's what Mr. Justice Beatson once called a Tennysonian wilderness of single instances, which is quite nice. Yeah, one of these cases is so idiosyncratic that it's just been kicked out of most textbooks. The Temple case, it was decided on the basis of, well, English law says this, but we're going to be a bit more open about how we apply that rule. But if you put them through the visor of public policy, you can see that there is some scope for that argument, but it's not been one that's been articulated particularly well.
Because they're even, I suppose, in the timeline, they're separated by quite a long time as well. You can't sort of see a 5-year period where there's been judicial activism.
Yeah, and this isn't really the sort of subject that judicial activism should, pop up in. It's very arcane. The most that you can see is this sort of homing tendency, this idea that I'm a judge of England, I want English law to apply, because it's really difficult to try and prove what the law of Germany is on this point. It's really difficult to prove what the law of...
Because I wasn't sure if it was a sort of, you could see like maybe the sceptre, would you say, of equity, or the shadow of equity still hanging over the judge saying, well, under the common law of equity might come in here, but I'm playing with concepts I don't know so much about, so I don't know if that, I thought that might be there.
Perhaps, yeah. You would see that as being a sort of equitable extension of public policy that hasn't been done before, and most people think hasn't been done since. If people don't like the idea that you can create rights out of nothing, especially if you're coming from or taking them from a system that wouldn't otherwise be applicable. But it is out there, and I think that it can be put to good use in the context of excluding foreign criminal laws and foreign revenue laws, because there might be very, very good reasons for justifying the enforceability of that claim. There might be very bad reasons, but to have it framed as a hard and fast rule, I don't like at all, especially when it's built on such frail foundations and been stretched to breaking point across myriad bizarre factual circumstances.
So you do have some faith in the judiciary, but
I don't like just the words public policy. Like, oh, we're going to do this because of public policy reasons. It's a bit like kind of because of natural law demands.
Yeah.
Or like, you know, common sense. It's common sense.
Yeah. Well, I mean, I tried to stray away from this because it's like a game of bingo. Whenever you're talking about public policy in IPL, you always mention what Mr. Justice Burroughs said in 1824, that public policy is an unruly horse, and no man should try and get astride of it. And of course, Denning in the 70s says, but with a good man in the saddle. So I wrote in an essay once that, well, why do we stick with the unruly horse of public policy when we have the thoroughbred that is the overriding mandatory provision? The answer is it's because legislators just don't use it. They just don't think, well, this is a situation where our law should have primacy. And if they don't do that, is it legitimate there for the courts to then go on to try and say, but the courts the Parliament must have wanted this, so we'll use public policy to try and secure the same result. I mean, theoretically, I find that a bit repulsive, but
a bit. It can never be a bit repulsive, but it's still like, come on. You can say
slightly repugnant.
Okay. Do we have any other questions?
I also just wanted to ask Bobby in an evil way whether, because I've got your argument seems very convincing to me, but you seem like maybe you're not convinced by your own argument.
It's based on very, very frail foundations. I think that it helps me to see in the thesis that there is a room for public policy stepping in and overriding strict rules of forum law. So why can't they do that for the rule that says you can't enforce tax liabilities here? So I think for that limited reach it works, but I wouldn't say that this is going to completely change the practice of how we do things. These are two exceptional cases that will probably never be repeated. Although there might be, because I'm aware that there's now a river in New Zealand that can sue in its own name.
Wow.
Yeah, I saw that. That's great. That's done.
Yeah. Well, we don't have, or do we want to talk about that river?
Well, I think
maybe a conversation for a different time.
Yes.
It's not really anything to do with anything that Bobby was talking about.
So thank you very much for coming, and thank you very much, Bobby, indeed, for this paper. It was really fantastic. So will we thank you in the customary way? Thank you. And thank you for tuning in online. It was nice to have you with us.